All right, today we're jumping into a real-life neighborhood showdown. This is a classic. A property owner going head-to-head with his Property Owners Association, or POA, out in a rural Arizona community. And this isn't just about some picky rules. It's really about what happens when your expectations for your property slam right into a very different reality. So, what pushed this thing all the way to a judge? Let's get into it.
So at the very heart of this whole case, you've got two pretty common complaints. What do you do when the road to your property is basically undrivable and you're convinced your neighbor is running a junkyard? And, the million-dollar question, who's actually responsible for fixing all of it?
Okay, first, let's meet the main characters in this drama. On one side, we have the petitioner, Thomas Stedronsky. Now, he bought an empty 15-acre lot way back in 2003. But here's a key detail. He doesn't actually live there. And on the other side, you've got the Copper Canyon Ranch's POA, which is the association that governs this whole community of 194 pretty large rural properties.
So Mr. Stedronsky's official petition really came down to two major gripes. First, he claimed the POA completely dropped the ball on maintaining Sundance Lane, which is the road leading to his property. And second, he argued that the POA was just looking the other way while the neighboring property, Lot 77, was turning into what he flat-out called a junkyard.
Let's tackle that first complaint, the road. This part of the fight is really a visual story. It's like a tale of two completely different paths inside the exact same community.
So, to build his case, the petitioner brings in photos of other roads in the development, and his evidence shows these roads are wide, they're graded, they look like proper dirt roads with good drainage. In his mind, this is the standard. This is what he's paying for.
But then, he shows the pictures of his road, Sundance Lane, and wow, the difference is just jarring. His photos show a path you can barely even see, all overgrown with weeds and covered in giant rocks. He even testified that to get to his own land, he had to go out and rent a four-wheel drive truck.
So how in the world does the POA defend this? Well, they didn't even try to deny the road was in bad shape. Instead, they pointed to their reality, and that reality starts with this number. Their entire budget for the year, from all the fees they collect, is only about $35,000.
And with that tiny budget, they have to maintain 20 miles of road for 194 different properties. But here's the real kicker. See this chart? Only about 35 of those properties actually have people living there full-time. The huge majority of lots, just like the petitioners, are sitting completely empty.
So, faced with that situation, the POA basically argued, look, our strategy is just based on common sense. With almost no money, the board made a call, prioritized the roads that are used every single day by the people who actually live there. Roads like Sundance Lane, that are rarely used, they still get some maintenance, bladed twice a year, but they just can't be the top priority.
All right, on to complaint number 2, the messy neighbor on Lot 77. Now, the petitioner saw a junkyard, but the question is, was it actually a violation of the rules, or was it maybe just rural living?
So, Mr. Stedronsky submitted a bunch of photos he took of his neighbor's property. And get this, he used a telephoto lens to do it. His captions describe a scene of inoperable cars, old license plates, and, as you can see in this quote, numerous vehicles with flat tires. For him, this was a slam dunk. Clear violations. But the POA? Well, they had a totally different take. The president testified that what looks weird to an outsider is often just normal practice out in the country. For example, keeping the hoods of your cars popped open, that's not a sign that they're broken down. It's actually a pretty smart way to keep rats and other critters from building nests in your engine and chewing up all the wires. The POA also made it clear this wasn't some new issue they've been ignoring. In fact, way back in 2013, the county itself investigated a similar complaint and just dismissed it, saying the property wasn't breaking any zoning rules. And over the years, the POA sent letters to the owner who, they said, had always been cooperative about cleaning things up.
So there you have it, two totally different stories, both backed up with photos and testimony. One side is screaming neglect and rule breaking, the other is saying no, this is just reasonable management and how people live out here. So how does a judge possibly weigh all that and make a final call?
Well, it all boiled down to a key legal standard, preponderance of the evidence. Now, this isn't like what you see on TV crime shows. It's not beyond a reasonable doubt. It simply means the judge has to be convinced that one side's story is more likely to be true than the other. It's all about which argument carries more weight, even if it's just by a little bit. And in this particular case, the weight of the evidence landed squarely on the POA's side.
On the issue of Sundance Lane, the judge decided the POA's strategy of prioritizing roads for residents was totally reasonable given their shoestring budget. And for Lot 77, the judge concluded the petitioner just didn't prove his case. Both complaints dismissed.
But hold on, the story doesn't quite end there. Because when you dig into the court documents, you find another whole layer to this fight, something that had been simmering for years and helps explain why things got so heated.
Tucked away in all the evidence was a string of letters, and they showed that Mr. Stedronsky had been complaining for years that the bad road and the messy neighbor were making it impossible for him to sell his lot. This all led up to a really blunt letter from the POA president right before the lawsuit, and this quote says it all. It suggests this whole showdown wasn't just about rules, but about years of frustration over a bad investment.
And that really leaves us with a huge question, one that applies to anyone living in a community with an HOA or a POA. I mean, if you buy a remote, rugged piece of land where the annual fees are tiny, what level of service can you reasonably expect? And at what point do your expectations just become unrealistic? It's a really fine line, and for these two, that line ended up being drawn by a judge in a courtroom.